This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below.
So when I first heard that William Leonard Pickard had been compassionately released from prison, I said, so what? And then I found out who he was. William Leonard Pickard is one of the people convicted in the largest LSD manufacturing case in history. Basically, without going over all the details, he was responsible for some 90 to 95% of the distribution of LSD in like the 1990s. So let's see what the judge has to say about releasing this man. In 2003, defendant William Pickard, along with co-defendant Clyde Apperson, was convicted of conspiring to manufacture, distribute, and disperse 10 grams or more of a mixture or substance containing a detectable amount of 2-lysergic acid dithylamide, LSD, in violation of various federal laws, and possession with intent to distribute and dispense 10 grams or more of a mixture or substance containing a detectable amount of LSD in violation of various other federal laws. Pickard was sentenced to life. The matter is now before the court on Pickard's motion for compassionate release. Pickard argues that this court should reduce his sentence in light of his age, his deteriorating medical condition, and the risk he faces from the COVID-19 virus, and the positive role he has played in writing about the fentanyl epidemic. The defendant has the burden to show that he should be released under the law. Even if the defendant otherwise shows that extraordinary and compelling reasons support a release, he must demonstrate that such a release is consistent with the sentencing factors set out in the law. Pickard is 74 years of age and has served 20 years in prison. He states in his motion that he suffers from chronic kidney disease, hypertension, anemia, hypothyroidism, cataracts, posterior vitreous detachment, prostatic hyperplasia, vitamin D deficiency, and prediabetes. The government's response focuses on Bureau of Prison efforts to reduce the spread of COVID-19 within its institutions. It argues that compassionate release should be granted based on the risk to the virus to inmates in general, while acknowledging that courts may consider whether specific inmates have underlying medical conditions which make them particularly at risk. The government argues that the court should not authorize release outside of the general medical conditions that warrant early release, as this will likely produce disparate results among defendants. The court first addresses Pickard's argument that compassionate release should be granted in light of the many publications and materials he has produced addressing and warning of the fentanyl epidemic. So, nothing to do with LSD. The court finds that such efforts do not justify release from the defendant's lawful sentence. Pickard's reply correctly notes that the government concedes his fentanyl work was praiseworthy, but at the same time entirely misses the context of the government's acknowledgement. The government is stressing that it was ironic that the defendant would submit his praiseworthy work in the field as a basis for release from prison when he ultimately decided that engaging in significant criminal activity outweighed his more altruistic notions. This is particularly true when the defendant had already been convicted twice for controlled substances offenses prior to his work on the impact of fentanyl and the instant federal conviction. The irony is plain, and the court finds that the defendant's publications are entitled to little, if any, weight in deciding whether to reduce his sentence. Pickard acknowledges in his reply that examples of non-medical reasons for compassionate release are rare, but he cites United States v. Walker as an example of such relief being granted in that case where the defendant had published a well-received book. This fails to fairly summarize the decision in Walker. In fact, the focus of the court's decision there was the minimum time left of the defendant's sentence, 14 months left out of an original 132-month sentence, combined with the medical condition of defendant's mother, with the court noting, quote, undisputed evidence that his mother is suffering from acute myeloid leukemia. Her prognosis is not good, and she requires expensive, non-traditional treatment due to a genetic issue that diminishes her response to more traditional treatments. The treatments available to her are generally less effective, higher risk, and higher cost than those available to other patients. The defendant's book was important only in that, because of it, he had received an unusual and lucrative job opportunity helping with a movie version of the book, and that would allow him to help with his mother's medical costs. The defendant here has failed to show any authority that a prisoner's good works, unrelated to a medical condition, should form a substantial basis for granting release from an otherwise appropriate sentence of imprisonment. Next, Pickard argues that the government's response errs in focusing on the wrong comment, the medical condition note. Pickard stresses that he is seeking relief under a different comment, the age of defendant note, based on his age of 74. Unlike the medical condition note, which applies where an inmate faces terminal illness, the age of defendant note applies only to inmates who have served at least 10 years and whose physical and cognitive deterioration has impaired basic human function without regard to whether these conditions, other than aging, are terminal. The defendant argues he should be released in light of his age and his health conditions, and noting that this court's decision in the Perez case suggests that at a certain point, no health issues at all are required. Stressing in particular his kidney disease, he argues that his condition is more advanced than the defendant in another case, the Lynn case. The court finds that Pickard's medical condition, standing by itself, independent of the risk presented by COVID-19, does not constitute extraordinary and compelling reasons for reduction of his sentence. Pickard received a sentence of life imprisonment, and it can be of little surprise that a person serving such a term may face some deterioration of health. The cases cited by the defendant are factually distinct. The defendant in Perez had served a decade longer in prison than Pickard, and, more importantly, the government essentially agreed that extraordinary reasons existed for release, arguing instead that the court should defer ruling on the motion for compassionate release until defendant's request for executive clemency was resolved. But Lynn is similarly quite distinct. In addition to kidney disease, the defendant in that case suffered a plethora of ongoing medical issues: high cholesterol, reflux, cervical disc degeneration, enlarged prostate, sleep apnea, high blood pressure, carpal tunnel, dental issues. Taken together, these might not indicate a serious deterioration of physical health, but there is much more, including hypertensive retinopathy, indicating that defendant's long-standing hypertension is in fact not controlled, degenerative changes, etc., etc., etc. The defendant has presented an expert opinion of a cardiologist that the defendant's condition is more extensive and severe than typically seen in patients their age. The defendant's medical records leave no question that his health is deteriorating. Pickard has presented the reports of two physicians. Dr. Cameron Baston reports that his review of Pickard's medical records indicates that he suffers from stage 3 chronic kidney disease, iron deficiency anemia, and pre-diabetes. He also states that he was told by email that the patient has hypertension, in direct contrast to Lynn, who suffered from multiple serious medical conditions presenting a present threat to his life, which were not due to the aging process. Dr. Baston writes that Pickard's conditions are occurring because of the aging process. Dr. Baston makes no attempt to document any imminent threat to Pickard's life due to his medical conditions considered separately. To the contrary, his report largely focuses on Pickard's medical susceptibility during the current viral pandemic. Dr. Thomas McNally's letter was similar. He does not indicate that Pickard's hypertension and kidney disease will likely result in adverse consequences by themselves. Rather, his report is exclusively directed at how the defendant's underlying medical condition puts him at risk for COVID-19. There is nothing in the record to show that Pickard's medical conditions are not adequately controlled in this prison environment. The defendant has not attempted to qualify his level of hypertension, and his hemoglobin test results suggest pre-diabetes, meaning he is more likely to develop diabetes in the future. That is, he is at risk of ultimately contracting diabetes. The defendant has failed to show, in terms of the policy expressed in the age of defendant note, that he suffers presently from a physical and cognitive deterioration which have impaired basic human function to the point that compassionate release is appropriate. The remaining question is whether Pickard's hypertension and kidney disease warrant a finding of extraordinary and compelling circumstances. The government stresses that Pickard is not required to undertake dialysis for his kidney disease. With respect to his hypertension, they write, "It is unclear at this time if hypertension is an independent risk factor for severe illness from COVID-19. Hypertension is common in the United States. It is more frequent with advancing age and among men, non-Hispanic blacks, and people with other underlying medical conditions such as obesity, diabetes, and serious heart disease. At this time, people whose only underlying medical condition is hypertension are not considered to be at higher risk for severe illness from COVID-19. This assessment may have been true at the time the cited guidance was issued, but the CDC currently advises that hypertension may increase your risk of severe illness from COVID-19. Similarly, the fact that defendant's kidney disease does not require dialysis is not dispositive. The CDC initially classified only those individuals with chronic kidney disease who require dialysis as being at heightened risk for severe illness, But under the revised guidance, having chronic kidney disease of any stage increases a person's risk for severe illness from COVID-19. The court concludes that Pickard is at greater risk than the average inmate of suffering a severe illness should he contract COVID-19, and further that he faces some risk of exposure to the virus. Unfortunately, the optimistic portrayal of Bureau of Prisons' efforts to limit the spread of the virus, as documented in the government's response, has been overtaken by events. Nationwide, the BOP has completed 34,000 tests, with nearly 10,000 showing a positive result. Pickard is incarcerated at FCI Tucson, where 11 inmates and 5 staff members have been diagnosed with the virus. No inmates or staff have died. Social distancing within the prison is difficult. A petition for compassionate release is not a class action challenging the BOP response to the pandemic, nor a vehicle to punish or reward the BOP for its response to the pandemic. Rather, the role of the court is to determine the relative risk faced by the prisoner, Pickard in this case, if he remains in prison, in comparison to his circumstances if he were released. Here, the defendant proposes that he reside with his family in Santa Fe, New Mexico, with Trace Cliffius, a government employee for the state of New Mexico over 18 years, and with his son Duncan, a pre-med student in the neuroscience pathway at a major Western university. His medical conditions will be treated at nearby St. Vincent's Hospital. His family will drive him from Tucson, have him tested for the virus at St. Vincent's, observe quarantine, and provide him with protective equipment as necessary. The court concludes that a compassionate release would materially reduce his risk from substantial injury. Having concluded that an extraordinary and compelling rationale exists for reducing his sentence, the court must determine whether his sentence may be reduced consistent with the factors set forth in the law. Under that law, the court, in sentencing a defendant, should consider the nature of the offense and the defendant's personal history and character, his sentence relevant to the nature and seriousness of the offense, the need for a sentence to provide just punishment, promote respect for the law, reflect the seriousness of the offense, deter crime, and protect the public, 4, the need for rehabilitative services, 5, the applicable guideline sentence, and 6, the need to avoid unwarranted sentence disparities among similarly situated defendants. The government argues that release is not appropriate because of his history of drug trafficking, this being his 3rd controlled substance conviction, and the extent of his LSD manufacturing scheme. As a result, a reduction would run counter relative to the nature and seriousness of his offense, and the need for a sentence to provide just punishment, promote respect for the law, and reflect the seriousness of the offense. Are we kidding? Seriousness with a 4 in it? You guys can't catch that as a typo? It also notes that defendants' conduct qualified for life sentences under both the guidelines and the relevant statutes. The court finds that a reduction in sentence is consistent with the sentencing factors. Pickard's offenses were serious, but having spent 2 decades in prison, he has been seriously punished. The government correctly points out that Pickard has prior drug convictions, but does not challenge the defendant's argument that the First Step Act's change to sentences for drug crimes would substantially change the treatment for his prior offenses. The fact that Congress has changed how such offenses are treated now is relevant to the determination whether a defendant faces disparities among similarly situated defendants. The government has not challenged the defendant's contention that at 74 years of age, he does not pose any significant risk to society, or that he has not engaged in substantial efforts at rehabilitation. The court concludes that the 20 years the defendant has spent in prison is sufficient to serve the goals of incapacitation, deterrence, retribution, and rehabilitation. The factors support reducing defendant's sentence to time served, to be followed by a 5-year term of supervised release. It is accordingly ordered that defendant's motion for compassionate release is granted, and his term of imprisonment is reduced to time served. So ordered by J. Thomas Martin, Judge for the District of Kansas. There you go. That's what it looks like to be compassionately released from prison. It didn't seem like it was easy. It didn't seem like it was automatic. It didn't seem like it was a shortcut or cop-out or punishment for the GOP or a political statement against the Trump administration's response to the virus. No, it's considering the risk of each individual defendant who is in prison who makes such an application. So let us know what you think. Would you have granted compassionate release? Do you think the sentence was too long to begin with? Do you think he's been really rehabilitated? Do you think he's a threat to society? Let us know in the comments. Keep it civil. Thank you. So that's our show, everyone. Thanks for joining me. I'm Leonard French, your favorite copyright attorney, and this is Lawful Masses, your favorite legal education and legal news channel here on YouTube, Floatplane, and Twitch. Thank you in the month of July to the following supporters on patreon.com/ljfrench and sponsors.org/law. We also include the YouTube members and Floatplane members in this as best we can. Special thanks to BU1 Simmons in the month of July. Thank you very much for your support. And thank you to the July $50 plus supporters, Nicely Done Defense, Joe Tyson, Wes Delj, Citizen of the Sovereign, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Spirit Bear, Jan Negrey, Michael Pearce, Daniel Perez, Blackleaf, Benjamin Hitov, Steven, Cute Grills in Your Area, Strawberry Puptart, Longreach Jones, Definitely Not Prenda Law, Ugly Grill, Shielo T, Gregory Conklin, Josh Baker, Rudolph Bescherer Jr., Oscar the Phrophet, Jay Dixon, Hot Grills in Your Area, Ameknight, and Brandyn Abel. And thank you to the July $5 plus supporters. I wasn't able to bring the LED Matrix panel with me, but we're going to find a way to get one and make one for our show here. I really don't want to do just a generic monitor. I want it to be something cool and technical like a LED panel. So thank you to all of the $5 plus supporters who are scrolling in front of me on the crawl. Everyone's going to be in the descriptions of the videos that drop. I'm Leonard French, your favorite copyright attorney. I will see you in the videos this week. I love you all. Bye.